How and when should schools distinguish between teenage banter and offensive language? How does extensive social media attention impact the handling of sensitive incidents in school? Is Missouri the new Florida? This is our second Missouri case in like 3 episodes. They're coming for the crown.
Today we're tackling a case that you might have heard about because it was in the news. This story sent shockwaves through a Kansas City community and captured national media attention. This is the case of Plaintiff A versus Park Hill School District. Now, you might know this case as the incident about starting a petition to reinstate slavery at a high school. Some students did this, right?
Well, they weren't trying to reinstate slavery at the high school, right? I don't think that was their message.
Yeah, no, this took place at a high school, and some students started a petition to reinstate slavery, period.
Right. And I remember hearing like this was a huge deal.
This was a big story. So this is a case that made national headlines in the media and caused headaches for school administrators, to say the least, right?
I can only imagine.
Not only did it raise some questions about student rights and administrative responsibilities, but also about the impact of media scrutiny on school discipline. All right, this one's interesting. It's got some twists and turns, so buckle up. Let's get into it.
Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. And now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right, Jamie, do you have our bell ringer for this week?
Yeah, I do. So this is, man, we had a lot of Supreme Court decisions come out in June, right?
It has been a whirlwind,
right?
Of a couple of weeks.
It's crazy.
At the end of June, early July. Yeah. It was hard to keep up.
I know. And, while you might think that very few, if you kept up with these, you might think that very few of those decisions have to do with education. I will say that one of them does potentially have some significant implications. So we want to talk about that in today's bell ringer.
And it's one that we've talked about or mentioned a couple of times, right? We've seen this coming.
Yes, exactly. So this is the recent U.S. Supreme Court decision in Loper Bright Enterprises versus Raimondo. And this decision overturned the long-standing Chevron deference doctrine. All right. So the Chevron deference doctrine, say that 3 times fast. Thank you. So that doctrine, which it was established in 1984, and that doctrine required courts to defer to federal agencies their interpretation of ambiguous statutes and laws as long as the interpretation was reasonable, right? So basically, what happens is the legislative branch writes up these laws and statutes and says this is what the law is, and hey, surprise, surprise, a lot of the time those laws were like, wait, what does this mean?
Right. They leave a lot of room for interpretation and implementation, right?
Yeah. And so in 1984, this doctrine was established to basically say when there's questionable stuff in those laws, when we don't know how to kind of deal with that stuff, we can go to the experts in those federal agencies that are that are going to be bound by those laws,
Right.
to help us interpret their meaning,
Yeah.
and how they're enforced, right?
Yeah, right. So these agencies from the executive branch have to interpret and implement these laws, and Chevron basically said, hey, as long as they're doing that in a reasonable way and, it doesn't contradict the statute, like courts, we have to defer to them. And Jamie, what I'm hearing from you is that may no longer be the case.
Well, according to the U.S. Supreme Court, that is pretty much no longer the case. And so we're talking about agencies like, in as far as we're concerned here, like the Department of Education, that's one.
Right.
But like this has huge implications for so many other agencies, the Environmental Protection Agency, financial agencies. I don't know what they are.
Yeah, I don't know those acronyms, right? But yeah, you're exactly right. Like this decision overturning the Chevron doctrine, which we've been kind of operating under for 40 years, right?
Yeah.
Like, so Congress has passed a ton of laws with this in mind. Agencies have ordered their work with this in mind. But, this is another example of the Supreme Court just kind of jettisoning decades of precedent. And it really kind of fundamentally shifts the balance of power in our governmental order away from these executive agencies, not necessarily towards the legislature, but towards, well, I guess the legislature and the courts, right? Like, the Supreme Court is now going to be the last word on what these statutes mean. And, maybe that's a good thing, but it also means that these agencies aren't going to have the same kind of authority to implement them. And so that kind of just means that like every regulation is going to be subject to challenge and interpretation by the Supreme Court. And, what we've seen from the Supreme Court recently is that they're not really, nothing seems to be settled anymore.
Yeah. And I think, to your point about, we've got this whole, country was sort of founded on this idea of separation of powers, right? You've got these three branches of government. You've got the legislative, you've got the judicial, and you've got the executive. And so basically, what's happening here is the legislative branch does its thing. And then for the last 40 years, the Chevron deference doctrine has basically said, okay, the executive branch can help interpret what's happening with the stuff that's coming out of the legislative branch, right? And the Supreme Court decision here kind of just, shifts that completely and says, you know what, we're going to take that power away from the executive branch and we're going to put it into the judicial branch, right?
Or the legislature, yeah. Yeah, because the legislature, so essentially, there's two ways to look at this. One is that these agencies, I think, it's clear that the agencies have lost a lot of authority, and there's been a lot of pushback against like what, we could call the administrative state and these unelected bureaucrats basically dictating a lot of American life. And like, I think there might be something to that.
Right.
But what this does is, there's two options. One is that authority gets transplanted to the courts because they're going to be the ones who kind of have the last say.
Right.
Or it's going to go to the legislatures to pass more clear laws or more clear delegations of authority. Because if the law delegates authority, then like basically says like, hey, we tell the EPA that they are authorized to interpret all of this stuff, courts are going to then, defer to that delegation. But I think we kind of all have seen how functional Congress can be.
Yeah. Well, and
right.
Yeah. And same thing with the courts. So like if this is putting a lot of the interpretation into the hands of the court, we also know how fast the judicial branch moves.
Right.
Right. And so when questions come up, it's a lot quicker for the executive branch to answer those questions than it is the judicial branch.
And they can bring a lot more expertise to bear, right?
Right,
like,
which was the argument that the dissenting opinion was talking about here, right? Like the majority, this was a 6-3 decision, and Chief Justice Roberts wrote for the majority, and they basically...
Along ideological lines.
Yes, so definitely along ideological lines. And Roberts, the majority's opinion was basically like, this is all about separation of powers, right? Like we've got to rein in the executive branch. And then in Kagan's dissent, she noted that it's the expertise that we're going to lose, the people responsible for carrying out these laws and putting them into effect. Those are the experts.
Right.
There's scientists at the Environmental Protection Agency, right?
Or educators.
There's educators at the Department of Education, right? And so now the laws that affect education, when come into question, for example, those questions essentially can't be answered by the educators at the Department of Education. They're going to have to be answered by Chief Justice Roberts and Clarence Thomas and Alito. Right?
Right. And the other members of the Supreme Court. Right.
And
so they're going to have the final say, right?
Yeah, they're going to have the final say. And that's it's an oversimplification of it, but that's essentially what's happening.
Right. Yeah. And so, to kind of put this in more concrete terms, we spent a lot of time talking about the new Title IX regulations, right?
Yeah, exactly.
Those regulations interpret the federal statute of Title IX. And now, after this decision, like how we are going to evaluate whether those regulations are going to be, allowed to stay in effect.
Right.
Loper completely changes the standard that's going to get applied as we evaluate those regs. And so before it was like, are they a reasonable interpretation of Title IX under Chevron? And now we've got Loper and, it's kind of all up in the air to see whether or not or how that's going to get applied. But so like, the Title IX regs are now kind of in, let's say, greater jeopardy. There's a ton of other regulations that affect education, everything from, student loans to students with disabilities, all of these different federal laws that have to get implemented by these agencies are now on less firm footing.
That's a good way to put it. Well, yeah, so there's that's the Chevron deference doctrine out the window.
Mm-hmm.
So that was our bell ringer for today. Let's get to today's episode. So today's case, it's a really interesting one. There's a good chance, like we said before, that a lot of you have already heard a little bit about this case when it was all over the news. But that's one of the reasons why we're talking about it. Not only is it a pretty interesting set of facts and the kind of thing that happens actually all the time. Maybe not petitions for slavery per se. But,
thank goodness.
But the kind of sort of banter that kids engage in can often cross lines, and that happens all the time. It happens everywhere. And this is the kind of stuff that schools regularly have to contend with. So that's one of the things that makes this an important and interesting case to talk about. But also, we've got the media angle, right? And that's huge here. So with respect to the media piece, school administrators are often advised to try to stay out of the papers more than they're advised to stay out of the courts, right?
Is that something you say in your classes?
I do. And I think most administrators can refer to some mentor that they had somewhere who told them, just stay out of the papers.
If you stay out of the papers, if you're not on the front page, you're doing a good job.
Exactly. And I think that's the reason why we advise or sort of in a tongue-in-cheek way, say to administrators, stay out of the papers more than we say stay out of the courts. It is because it's partly obvious that one would want to stay out of the courts, right?
Right.
It's probably also because media coverage of some situations can take a far greater toll than a lawsuit might.
Or lead to a lawsuit.
Or it could lead to a lawsuit. Yeah, but even in cases where there's clearly no established violation of law, and in situations where the law will never come into play, media coverage can take a big toll on a school's reputation or the reputation of particular administrators.
For sure. Yeah, it adds a whole different layer, right?
Exactly. And the media was all over this case, obviously, because it made national news. So let's dig into Plaintiff A versus Park Hill School District. Are you ready?
Ready. Now, that's not the student's real name, is it?
I don't think so. I mean...
No, we don't have their names. We just have A, B, C, and D.
And there's also a TRL, which is not
Total Request Live.
There are 5 big student players in this story.
A, B, C, D, and Carson Daly.
A, B, C, D, and TRL. Okay, so here's what we've got. We've got Park Hill School District, which is in Missouri. All of the plaintiffs we are talking about in this case, A, B, C, and D, they're all in 9th grade at the time. They were all members of the school's 9th grade football team. It is important to mention, because this case has a lot to do with race and racism. Plaintiff A is biracial, Black and Brazilian. Plaintiff B is white. Plaintiff C is white. And Plaintiff D is also biracial, white and Asian. TRL, who is the 5th student involved here, is a Black student. All right, so all of this starts out in September of 2021. All right, September 16th, 2021. All these students are on a bus going to an away football game, And what happened was they were all sending Snapchat messages and videos back and forth. And this is from what I hear, how the kids communicate these days.
I mean, we already showed our age talking about Total Request Live.
Yeah, I know. Well, I was just talking to somebody the other day who has, my kids are little and your kids are little. But I was talking to a friend of mine who has a teenager, and he was saying to me, he was like, they don't call, they don't text, they don't email, and I knew they didn't email, right?
Yeah.
And I knew they didn't like calling, right? But I thought texting could still be a thing, but apparently it's not really that much of a thing anymore. Everything is done through Snapchat, which is interesting.
Yeah.
So anyway, all these kids were all on Snapchat on this bus, sending messages and videos back and forth. And that is probably the extent of what is clear about this case, right?
Right.
So A, B, and C are on one bus. Plaintiff D is on another. Again, they're sending all these Snapchat messages and videos back and forth. It's unclear how they got onto the topic of slavery or who said what to whom and when about it, but somehow the topic of slavery came up, and according to one version of the events, Plaintiff A overhears some other kids talking and joking about TRL, the student, not the TV show, about how TRL needs a job. Reminder that TRL is a black student, okay? Plaintiff A and another student were engaging in playful bantering, that's the quote, engaging in playful bantering about jobs and slaves, a subject first mentioned by TRL.
According to Plaintiff A,
According
right?
to Plaintiff A, TRL first made that statement, right? About slavery and jobs and whatever.
Yeah, and that phrase playful bantering is doing a lot of work there.
Well, it's going to do a lot of work in this case, isn't it? Like all throughout.
Yeah. Right. Like, I guess that is the plaintiff's version of
events. Hey, we were just joking around.
Right. And that's pretty much their defense this entire way through, right?
Exactly. So again, like it's really unclear how involved TRL is in this whole bantering back and forth. And so a lot of the information that we're getting here is coming from the plaintiff's version of events, right? So the plaintiffs suggest that TRL was involved in creating the petition and that he laughed about it and was fine with it. And the petition here is about reinstating slavery. So they went on change.org and created a petition to reinstate slavery and then started circulating this thing, right?
Right. And yeah, the petition was called, I think it was titled, Start Slavery Again.
So let's talk just a little bit more about this petition, okay? So what is clear is that the petition was drafted on change.org by Plaintiff A, all right? It was titled Start Slavery Again. And what happens when you create this petition on change.org is it asks you to upload an image and say who the target audience is and who will benefit from that petition, all right? So somehow that petition used TRL's photo.
Okay.
And it said that the target audience was, quote, racist men, unquote.
Yeah, that seems appropriate.
All right. And okay. And the intended beneficiaries would be, you guessed it, white men. Okay. So Plaintiff A testified that TRL encouraged him to write that the target audience for the petition was racist men. Okay.
Yeah. So just unpacking this petition a little bit, it uses TRL's
image
picture.
Yeah.
And that, I think, like, that is a huge red flag for me for everything that's going to come, right? Like, I guess that makes it targeted. It makes it directed. It's not just this amorphous thing anymore. Now it is very much like specific about this student.
Right. But I think this is part of the murky part of the case is that Plaintiff A is basically claiming that TRL was involved in this whole thing.
Yeah, I don't know how much
signed off on it, right? Like he was aware that they were using his picture and he was aware that, and involved in the creation of the petition. This is according to Plaintiff A.
Right. And I don't know, like, even still, I don't know how far that gets Plaintiff A, but, I guess it does mitigate the, like, targeted nature of it. But and then
At least a little bit, I think.
at least a little bit potentially, right? But
Right.
it's still, you put, and change.org, this is a public forum, right?
Yeah.
You can't control who sees
No.
a change.org petition
No.
as far as I know. And so
Yeah, this isn't contained to Snapchat anymore, right? That's
Right.
right?
yeah. And that's another big part of this is how far and how fast this thing spreads.
Yeah.
Right. Is a big piece of the puzzle.
Yeah.
And so I know the kids or the students, plaintiffs A, B, and C, and D are all kind of saying this was a joke. It got out of hand.
TRL was aware and involved in the creation.
Right.
That's what they're all claiming.
Yeah. And there might be something to the idea that this is satirical, right? They put the audience as racist men and the beneficiaries as white men. That to me tends to in their adolescent way, they're doing some poorly informed social commentary. And that is the best interpretation of what they're doing that I can give them, right?
Yeah. Or just completely tasteless banter.
That is probably a more realistic interpretation of what they're doing.
Right.
Yeah.
So again, they create this petition. Plaintiff A creates this petition, but claims that TRL, whose picture is on the petition, right, claims that TRL was involved in its creation, right? Now, TRL's version of the story is a little different. In a deposition that TRL gave, he said he did not remember any jokes of him needing a job or any jokes about slavery. He said he first saw the petition when Plaintiff A was creating it because he looked over his shoulder while A and B were laughing about it. So he's basically saying, I wasn't involved. I only saw it because they were laughing about something. I looked over at over his shoulder and saw it.
Right, which adds a whole different, really problematic layer, right? If that is the true version of events.
Right. And he also said he didn't laugh about it. He said nobody asked him if it should be posted or not. He said he didn't agree to allow his picture to be used. And he said that other students on the bus were telling Plaintiff A not to post this thing because, quote, people were going to get in trouble. So again, according to Plaintiff A, TRL was involved. We're just kind of messing around and, no big deal, right? And according to TRL, he's like, no, it was a big deal because people were saying, wait, you guys are taking this too far. And he was also saying, I don't want any part of this. I was never consulted. No one asked me, if they could use my picture. So we've got two very different versions of events here.
Right.
Okay.
And both of them are problematic in their own ways.
Yeah.
The one with TRL not being involved, obviously significantly more problematic.
Right. Right. We don't exactly know where the truth lies here.
Mm-hmm. Probably somewhere in the middle.
Somewhere in the middle, which is where it typically lies, right? And so some background on this. So at this point, we've got two different stories essentially about this petition, but we've got this petition that has been created, and that is an indisputable fact. So as part of the plaintiff's versions of events, the plaintiffs alleged that the use of racial slurs at this high school, that was common, okay? And they were often used in friendly, bantering. They were used in the locker room, within the hearing of coaches or other adults, and this kind of stuff was generally tolerated. It sounds like they're describing this as just benign bantering that did not rise to a level of severity that would cause concern by adults within earshot.
Okay. So this idea, so what they're kind of arguing here is that this is just par for the course in this school community or this team or whatever.
Yeah, pretty much.
Okay.
Yeah.
And that this isn't out of the ordinary. Yeah.
Yeah. I mean,
again, this is their version of events, right?
This is their version of events, right? So, they get to, all of this stuff is going around through Snapchat and whatever. They arrive, they play the football game. At some point that day, other members of the team start liking the petition, right?
Right. They signed the petition, right?
Yeah.
This all got out because student A sent it to the football team's Snapchat, right? It wasn't just he created it. He also shared it through Snapchat.
Yeah.
Okay. Yeah. So everybody on the football team, whoever's in this group has seen this petition now. It's not just a joke in air quotes.
And they're liking
right?
they're liking the message on Snapchat and everything. And some of them start posting comments So Plaintiff B posts a comment that says, I love slavery. Plaintiff B is white. Plaintiff C, also white, says, quote, I hate blacks. Plaintiff D, the white and Asian biracial student, posts, I want a slave.
Okay.
Yeah, so it's starting to go further.
Yeah. No, it, obviously can't understand why they would post this stuff on a public website, right? Like change.org is not Snapchat. It doesn't disappear in 24 hours. That is a public comment on a public website.
Yeah. So according to Plaintiff A and the other plaintiffs, B, C, and D, the kids who posted, liked, or commented on that petition, as well as TRL, who they said, again, participated in the creation and sharing of the petition. All these plaintiffs said that everybody viewed this thing as a joke, and those who commented on it wanted to be in on the joke. That's it. They just wanted to be a part of everybody knew this was a joke, and they just wanted to be a part of it. Okay?
So maybe they're being the adolescent version of satirical, right? Like, I guess that, again, and that's the most generous interpretation of their actions that I can give them.
Yeah. Now, of course, what pretty much always happens with Snapchat, despite its nature as sort of this closed ecosystem where, you're sharing messages, to a specific group and it's not out there for public consumption, as what always happens, somebody posts something on Snapchat and somebody takes a screenshot or whatever, and then it's out there for public consumption.
Right.
Which is exactly what happened here.
The Brandy Levy case taught us that, right?
Exactly. And so then it's out there. It's out there in the community. The school hears about it. Members of the community hear about it. And then the social media outcry takes off.
And it went around the world before everybody had all of the details. Because I vividly remember seeing this on my feed and people sharing this with me.
Yeah.
Because the petition got out before it was clear who created it. And so all anybody knew about the petition was it said, start slavery again. It was created by, they didn't know who created it. So everyone just assumed that it was a white student who created it. Yeah. And it was this big social uproar, right?
Yeah. And so all the details that we've sort of shared with you so far about who was involved in what, and the fact that there's two different versions of the story and whatever, none of that stuff was out on September 17th, the next day, when all of this stuff is going viral. Right. So that next day, September 17th, what happened was the assistant principal interviews the 4 students who all admitted their participation and characterized it as a joke. Okay, so no surprise there, given what we've told you so far. The assistant principal then gives them disciplinary notices informing them that they are all being suspended for 10 days with recommendation for long-term suspension or expulsions for violating multiple school policies, including cell phone use, disorderly conduct, disruptive behavior, and harassment. Now, it's probably important to just quickly mention here to our listeners that there is a very important sort of demarcation between 10 and 11 days worth of suspensions in schools.
Right.
For those of you who don't know, and there are a number of court cases that have sort of helped establish that sort of demarcation. Basically, there are certain due process requirements that every student is afforded when disciplinary actions are taken. And those due process actions essentially differ when you are being disciplined or suspended for 10 days or less versus 11 days or more. So if you're going to be suspended for 11 plus days,
you get a lot more process.
You get a formal hearing, stuff like that. Whereas 10 days or fewer could be, again, this is all state and district specific, so you'd need to know your policies, but informal notice saying, we think this is the information that came to our attention. We think you broke a rule. We're going to suspend you for 5 days. They can give you an opportunity to tell your side of the story, but they don't have to believe you.
Right. Yeah.
Right?
For a suspension of 10 days or less, you just need notice in a hearing, which is notification of the charges against you, an opportunity to tell your side of the story, and an opportunity to hear the evidence against you. After that, it can be really informal.
Yep.
It can be a conversation like this in the morning
Yep.
for the assistant principal,
Yep.
and you're done.
Parents don't need to be involved.
From a constitutional perspective, right? From a statutory perspective, who knows what Missouri's laws say about statutory due process.
Yeah. So basically what happened here was they were saying, you're getting the maximum under that process
before we
standard.
have to do more procedural steps. And that also said like, and by the way, we're probably going to kick those bigger procedural steps off here in a minute.
Yeah. So they gave warning that was going to happen. Mm-hmm. All right.
Yeah. In the law, we call that notice.
Oh.
Yeah. And like this all happens the very next day. So like kudos to this principal and this school. Cause like, you know, I think a lot of what we do in these cases is we kind of like problematize how the school reacted.
Yeah.
Right. And that's just kind of the nature of lawsuits.
Yeah.
You know, they don't come around when things went right.
Yeah. Exactly.
And, you know, I think this is one of those situations where like the school is on top of it. Like they are
less than a day later after this event. Mm-hmm. Right.
They're timely. They're responding. They're like doing the thing that I love, which is, you know, responding to speech with more speech. Like they're articulating their message about the school being a safe place, like all of these different things about like, you know, this language, this racist language is not going to be tolerated. Like,
yeah. So what you're talking about here is basically what they did later that night. The principal actually sent a mass email out to the whole community, basically saying what you were just saying. Right? Like reiterating what happened, that there were unacceptable and racist statements that students posted online during a school-related activity. And they sort of reiterated the school's stance on all of this stuff.
Right.
Right.
And that's so important that it happened like within
it's about 24 hours.
24 hours.
Yeah, pretty much.
Right. Yeah. Because at this point, like it made it on Twitter within like, I think 5 hours of when the petition was created. So like it has already gone around the world twice at this point.
This was one of those situations where, you know, if the principal was not at the football game that night, it's entirely likely that the principal went to bed that night with like, okay, just another day. I'm going to see everybody tomorrow, and woke up to you know what show at 6 a.m. the next morning. This stuff goes fast.
I've had those mornings. I'm sure you have too.
I have. Social media is fun. So,
but yeah, so, you know, good on them for being proactive and for very clearly articulating their values in light of this, because I think the worst thing they could do is just be quiet and let everything play out without kind of having their perspective represented.
Yes, exactly. So a couple days later, principal sends the parents of the plaintiffs letters informing them of the suspensions, okay, as well as informing them that they're being recommended for long-term suspension or expulsion, because as the letter stated, the discipline was the result of harassment, disruptive behavior, disorderly conduct, cell phone electronic device usage violations, and specifically said that the conduct in question was unacceptable behavior pursuant to Park Hill disciplinary policy, as it is prejudicial to good order and discipline or tends to impair the morale or good conduct of students. So they're basically saying, this is the policy, and these were the rules that were violated. Okay?
Mm-hmm. Which is really important for that notice piece that we just talked about, right? Like, here are the policies that you are alleged to have violated. Mm-hmm. Here's how we think you violated those policies. And we're telling you we're going to keep going through the process.
So the next day the parents were notified that there was going to be a disciplinary conference on October 1st. And it included all of the information that it needed to include, like notice of charges, what sections of the code, like you were saying, were violated. So all of the schools providing all of the information to parents.
And that's within what, like less than a week of when the petition was made?
Yeah, totally.
So this is moving fast.
It's moving fast. Superintendent gets involved pretty much right away, emailing a letter to the community that condemned the petition.
Yeah, and this is one of those situations where I think the superintendent was rightfully involved, right?
Totally.
This is not
because this is out there, right? Like, you know, if the media is all over this at this point, you know, for the superintendent not to be involved in this point would probably be like, you know, when it comes to this kind of media coverage or whatever, you would think the superintendent would get involved.
Right. You need the district figurehead, right? Yeah. Like you need the person in charge. This isn't a 2-minute cheerleader sit-in.
No, exactly. Okay. So they hold the disciplinary conference. Plaintiffs in that were given the opportunity to explain their conduct. After the conference, the school gave all 4 students 170 days of suspension and recommended that student A be expelled.
Because student A is the one who wrote the petition.
Yes,
or published it, right?
Yeah. So in this hearing, they considered two related incidents. So according to the court records here, it says the first incident involved a student writing racist and threatening graffiti on school bathroom walls and resulted in the student being recommended for expulsion. The second incident involved a student drawing swastikas on school bathroom walls and resulted in the student being expelled. So the school has set some precedents with racist
student speech. Yeah.
Racist speech. Exactly.
Yeah. Okay. And so they're basically comparing this to those incidents to say, like, our punishment is in line with prior practice.
Exactly.
Okay.
So shortly thereafter, it was about a month after, in the early November, the school board held an appeal hearing.
So think about like all of the process that the students are getting here. Like they had that informal meeting with the vice principal or the assistant principal.
Yeah. All of those communications were being sent out to parents.
Yeah.
With all the detail. Okay. Then they had the formal hearing.
Right.
Then which they essentially lost. And then they were given the opportunity to go through the formal appeals process that the district has.
And appeal it to the school board.
And they appealed to the school board, and the school board upheld the district's recommendations for suspension and expulsion.
Right. Yeah. Because the board is actually the entity that expelled Plaintiff A and then upheld the other suspensions. Right.
Right. Exactly. And the interesting thing, one of the things that I read in one of the news articles about this case is that as quick as all of this stuff went down the first couple of days, when it came to making these decisions, these big decisions about what should happen with these kids, it wasn't just like, a bunch of people walking into a room and saying, who cares, throw the book at them, we're done. This board meeting in November was 10 hours long.
Wow.
It started on November 3rd and ended on November 4th. Yeah, they didn't get out of there until 3 a.m.
Oh, wow.
So now those board members know what principals feel like in terms of working hours.
There you go. I was going to say, I've sat through my fair share of school board meetings. And yeah, so all that to say, like, if it's a 10-hour meeting, these students definitely had the chance to tell their side of the story. And I think at that hearing, they had their parents there. They all had
attorneys.
At least some of them had attorneys, legal counsel representing them. Yeah. And so like they were able to call and cross-examine witnesses. So like, no wonder it took so long. It was basically a mini trial.
Yeah. They also decided that in order for plaintiffs B, C, and D to return to the school the following year, they had to do 10 hours of diversity and inclusion training. Like they're going through the process here. You want to talk about due process? Like,
right. And you got to imagine they had the rule book in their hand every step of the way, because if they make a misstep here, like it becomes such a huge issue. So like, following your stated process and procedures is always super important, doubly so when you're under the microscope like this. So like, I got to imagine they had so many conversations with their attorney going through this, just be like, hey, this is what the letter's going to say. Is this good?
Yeah.
Hey, when do I need to do this? Like,
well, and the main reason is because this is the area where most schools, when it comes to disciplinary legal proceedings and stuff, this is the area that most schools get tripped up on, is the process part of due process. Remember, we've talked about this on the show before, is that the two kinds of due process claims that can be made here are substantive due process, which is a really sort of high bar and a complicated thing to sort of wade through, and procedural due process, which is like, did you check all the boxes?
Right.
And most schools get hung up on, we forgot to check that box, or we didn't check that box right, or whatever, right? And that's where they can lose. And so, going through this at this level of detail is like good on the school, good on the district, because you're going to potentially, if you can do that well, you're going to cover yourself in court, which, hint, hint, they did. Not to get ahead of ourselves here. But anyway, they went through all this kind of stuff. The school even coordinated with an accredited online public school that could allow the plaintiffs to receive educational services during the 2021-2022 academic year.
Okay.
So like while they were being suspended, the school coordinated with an online, a virtual school, to basically say, keep these kids learning.
Okay.
Okay.
Nice.
Yeah. So essentially they were allowed to transfer to this virtual learning school from their in-person high school. They still had access to the high school counselors. So like, I don't believe that the school had necessarily any obligation to do that from a legal standpoint.
Probably depends on state law.
It could depend on state law, but that's a nice perk to have after you've been suspended or expelled.
Yeah.
Right?
And it kind of goes to something that I like to hit on a lot with student speech is like, it's so, because of the nature of schools and the nature of these young adults, like they're learning, they need time to practice and to kind of like process all of this stuff. So like, I think in this situation, clearly punishment was appropriate. Using it to help them learn, like that's why I really like the like, we're going to keep them learning through this learning program. We're going to make them go through DEI training. Like that, I think is such a smart play here because like, hey, you did something that was really, really problematic, really harmful to a lot of people. Yeah. And you, when you did it, at least didn't seem to understand the impact it was going to have.
Right.
So please get some, like, here's some context, here's some learning, like, we're going to help you develop. So like, I applaud the school, not only for following the process, but also how they handled it.
Yeah, exactly. Okay. So, before we hit, how the courts dealt with this, just a couple other interesting facts that I came across when doing research for this case. And it's, it just goes to show how intense these things can be. So the superintendent said that this event caused the most disruption that she had experienced in her 40 years in education. Now, listen, that's a
long career.
It's a long career. For a superintendent who's been in education for 40 years has probably seen a lot.
Has some war stories.
Okay, and so this one to say this is the most disruption she had experienced, okay, that's saying something. Right?
For sure.
The principal estimated that the school's administrative team spent more than 310 man hours just on this situation.
Wow.
Dealing with the fallout of this situation.
And that's not one person. That's like the whole team.
That's still the whole team.
310 hours.
Yeah.
That's how many work weeks is that? That's almost 8 full work weeks of individual labor.
It's a lot. And keep in mind, it's not just doing the things that we've talked about so far. It's not just about making sure their ducks were in a row in terms of, providing the parents with a letter and it wasn't just about that. It was about managing their community. Right?
Right.
So they were, they had to deal with really upset teachers who were in the building teachers who were calling them saying they were worried because their classes were being significantly disrupted by all of the chatter that was going on about this event. The teachers were saying that all that they're doing is fighting fires all day, is just trying to keep kids contained and calm and keep the learning going. They were saying that several girls, they were calling the administration saying several girls are crying and they're scared for their lives. Teachers were feeling helpless. They were asking administration for guidance and support. The principals were quoted as saying, "I've been doing a lot of counseling today," which just reinforces how teachers and administrators are much more than just the person who teaches you math, right? Like,
right.
This thing sent shockwaves through the community. And that's what we mean by like, it's not just parents who, the social media outcry and, the media coming and knocking on your door saying, "Can we get a statement?" It's like, this is percolating through the school and principals and admin have to deal with this. Like, this is a big thing.
Right. Yeah. Because imagine all of the parent phone calls and, the students' reactions too. Like all of those little just instances where they need affirmation, they need support,
right?
They need to hear that they're valued, that they belong, that this doesn't represent the school. All of those different small things. Like I can 310 man hours, now that I'm thinking about it in that way, that's probably an underestimate, to be completely honest, because, 310 hours, that could get you through the suspension and the expulsion hearing, right?
All this other
10
stuff.
hours, especially if you're doing 10 hours of a school board meeting, right?
Right.
But that's wild. And it shows when we talk about Tinker and student speech, we talk about substantial and material disruptions, right? And so
exactly.
Here, in ways that hasn't been evident in some of our other situations, I think we've got a pretty strong case for material and substantial disruption, right?
That happened. Yeah. So how did this resolve?
Yeah. So this is one of those situations where it seems like the school kind of did everything right.
Right.
But the plaintiffs, given the context, they brought a lawsuit against the school district. So plaintiffs A, B, or students A, B, C, and D all brought a lawsuit against the school for basically challenging their suspension and expulsion, saying that the school violated their First Amendment rights to free speech, their 14th Amendment rights to due process, and their 14th Amendment rights to equal protection.
Interesting.
Yeah, so some interesting claims here. And then the last one is that the school failed to appropriately train and supervise its staff to avoid constitutional violations. So a failure to train claim.
Okay.
And so they bring this lawsuit in November of 2021, and the plaintiffs move for a preliminary injunction, basically arguing.
Well said.
Hey, first try too. See, this is what happens when you do 22 episodes.
Yeah.
You get good at saying the words you can't say. So they do this preliminary injunction, and they're arguing that the school should be prevented from enforcing the suspensions and expulsions.
Okay.
So basically, they want an injunction to stop the punishment.
Yeah. Okay.
While the case goes through.
Got it.
And so the trial court, and we're in the district court for the Western District of Missouri. So these are federal constitutional claims, so we're in federal court. And the court hears this motion for an injunction and denies the motion.
Okay.
Looks at all of these claims and says that, you know what? You haven't shown a likelihood of success on these claims, which is what you have to meet in order to get a preliminary injunction. And so without a likelihood of success on any of these claims, I can't give you the injunction. The case is going to move on.
Oh, okay.
Yeah. So one of the interesting things about this preliminary injunction decision is it is the only time that the court deals with the First Amendment claims that these plaintiffs are making, because right after the court denies the preliminary injunction and says there's no likelihood of success on these claims, the plaintiffs dismiss their First Amendment challenges.
Wow.
I know. And that was like,
why?
I guess because they got denied at the PI stage, right? Like,
well,
that's
yeah,
why
but like of their claims, that one seems the potentially strongest one. Like the due process claim, it's like, to me, is like the school did so much, right?
Right.
From a due process standpoint, if there's going to be one, you're going to say, all right, we probably won't win that one. It's the due process one.
Right. So you hang your hat on the First Amendment one, right? Like,
well, that's interesting.
I don't know. And that's why, like, I went back and looked at the PI, because I was so shocked to not see the First Amendment claim later on in this case. Like, just trying to figure out what happened to it. And so the court looks at, and, maybe they just saw the writing on the wall after the preliminary injunction decision, because the court said, essentially, I don't think you're likely to win this one.
So then why wouldn't they have just dropped everything?
And I have no idea, right? Like, why drop just the First Amendment
just
one, not everything? Yeah.
Well, all right.
So the court looks at their First Amendment challenge, and we've talked about the First Amendment a bunch, but there are certain categories of speech that schools can regulate: indecent, lewd, or vulgar speech that is reasonably interpreted to promote illegal drug use, speech that bears the imprimatur of the school, so basically speech that is school-sponsored in important ways, or, and this is Tinker, speech that materially and substantially disrupts classwork or involves substantial disorder or invasion of the rights of others. So, like, those are our categories. And here, the students are trying to argue, like, hey, this was, it doesn't fit into any of these categories, so therefore the school couldn't punish it. And they're also kind of hinting at this argument that, like, wait, we were just on a school bus, but this is all on social media. It wasn't done during a school event.
But also the Tinker standard didn't, while we focus a lot on the material and substantial disruption part of Tinker, didn't Tinker also say that speech that violates the rights of others is also impermissible?
Yeah, speech that invades the rights of others. Yeah. So, like, that's where a lot of the anti-bullying or anti-harassment legislation
which
comes
is what
in.
Some of the school was claiming this violated their harassment policies and whatever. So okay.
Yeah. And so the students, are trying to, like, get this put into the off-campus speech bucket, because
the courts have repeatedly said that you can't play that card, buddy.
Right. Just because you're off school grounds, you are on a school bus going to a school-related activity. So this is very much
bong hits for Jesus, right?
Yeah, right. Yeah, exactly.
Yeah.
The Morse v. Frederick case.
Yeah.
So, we talked about Brandy Levy versus Mahanoy in episode 3. That's the off-campus
speech.
Where schools have a lot less authority to regulate speech. Here, though, this is pretty clearly part of a school-sponsored activity.
Game. Yeah.
Exactly.
Yeah.
And so we are firmly in Tinkerland. That sounds like something that should be at Disney World, right? So we're firmly in Tinker, and Jamie, you kind of already articulated like all of the substantial disruptions that occurred here. Like this was a huge disruption to this school, this community. It wasn't just like one classroom for 5 minutes, right? Like this was a massive disruption that required a lot of man hour and a lot of like very careful navigating.
Exactly.
Yeah. So the court looks at that and just basically says like, that there's not enough here. Like students, I've got a pretty strong evidence or a pretty strong case that there was a material and substantial disruption. And after I've got that, like the school acted reasonably. So you're not going to win this First Amendment claim. And so the court goes through the same analysis for their 14th Amendment due process claims and says, you know what, you're probably not going to win any of these either. And so they deny the preliminary injunction. And that's when the plaintiffs dismiss their First Amendment claim. And they also dismiss their failure to train claims. So the only claims left, Jamie, you said, were the due process claims and the equal protection claims, which to me are their weakest claims.
Weakest claims.
But maybe they didn't want more evidence to be.
Do you think they just got mixed up?
No,
I hope get rid of two of them.
Right. Yeah. Well, I think, maybe if they're going through discovery, they don't want the school to be able to basically put on more evidence of how disruptive this was or like the negative impacts that this had on the school community. So maybe like in order to keep that evidence out of the record, they dismiss the First Amendment one because now the disruption isn't relevant. And if they get rid of the disruption stuff, then that actually might strengthen their due process arguments because one of their due process arguments is that the school overreacted to their, basically the punishment was disproportionate to the alleged misconduct.
So it was a substantive due process claim and not procedural?
They brought both, yeah.
Oh, they brought both. Okay.
Yeah. So we go through discovery, and after we get through discovery, the school files a motion for summary judgment. And on January of 2023, the trial court grants the defendant's motion for summary judgment on all of the remaining claims.
Oh, really?
So procedural due process, substantive due process, equal protection. Obviously, students don't like that outcome because they've already dismissed half their claims and now they're all gone. And so they appeal that to the 8th Circuit Court of Appeals, who look at this
and say, we agree.
And say exactly that. We agree. They affirm the trial court's decision granting summary judgment for the school. So because this is a summary judgment motion, we view the evidence in the light most favorable to the students because the school's the one moving for summary judgment. So, we've already kind of talked about like the different versions of events here. The court says like, for purposes of this, I am taking the plaintiffs at their word, right? Like I'm drawing all of the
inferences. Give them the benefit of the doubt.
Exactly. And even with that, there's not enough here to survive the motion to dismiss. So looking at those due process claims, Jamie, you already kind of alluded to procedural versus substantive due process. They don't really, they try to make a procedural due process argument, basically saying like, hey, we didn't get enough process, or you didn't do the right steps before you deprived us of our entitlement to education. And the court looks at that and just kind of says, you know what,
that plane don't fly.
that dog don't hunt. And then they get to the substantive due process claim, which is a little bit harder to understand in some ways, but basically substantive due process just prevents the government from engaging in arbitrary or capricious
over-the-top reactions.
Exactly. Yeah. It basically like tempers the government's authority. And so in order to
it uses that sort of reasonable person standard, right? Like it kind of looks at, did the government react in a way that would shock the conscience or would say, whoa, I can't believe you did that.
Right. Yeah. And that's kind of the two flavors here, right? One is like, it has to be conscious, shocking behavior. Like a person would have to look at this and be like, I can't believe the government just did that to you.
Yeah. So basically what they're looking at here in this particular case is these kids, whether it was playful banter or not, they engaged in racist sort of harassing sort of speech, right? That caused a significant disruption to the school community, and you got suspended for it.
Right.
And they basically said that doesn't really shock the conscience.
Exactly. And so it's not conscious shocking because of all of the reasons the school said. Like, they had a good reason to do what they did. And they even showed similar situations that were handled the same.
Exactly.
And so, like, you know, they've got past practice to fall on, all of that. So, like, it's very much not conscious shocking because, like, you know, the court even says, like, suspending students is a pretty standard thing that schools do. And, like, they have a lot of discretion to do that. And the court can't say that, like, 170-day suspension for, you know, the amount of disruption and the harm caused by the speech and just, you know, like the nature of the speech itself, right? Like, those comments were pretty egregious, and the petition is pretty, you know, incredibly problematic, right?
And so, courts are pretty reluctant to weigh into the specifics of school discipline.
Right. They're not going to second guess school officials, for sure.
They're just basically going to focus a lot more on whether or not the school violated any constitutional protections.
Right.
For the most part.
Yeah. And this shocks the conscious standard is a pretty high standard. And, you know, the court looks at it and says, the school acted reasonably here, right? Like, there is a reasonable connection between the punishment and the alleged misconduct. And so we are not going to second guess that. And there's no evidence here of ill will or bad faith. Yeah. And, you know, in absence of that, like, we're going to defer to the school's reasonable conclusion.
Yeah.
And then, you know, that gets us to what I think is their weakest claim, which is their equal protection claim. And so equal protection just requires that the government treat similarly situated people alike. And so but
even there, like, they're showing past precedent. Like, anytime a situation like this comes up, this is what we do. And you did it. And so we're going to do the same thing.
But that's not what they're arguing. The students here are arguing you suspended A, B, C, and D and expelled A, but you didn't punish TRL. And that's their argument. Their argument is, if you're going to punish us, you also need to punish TRL, because their argument is essentially that TRL was involved in the creation and distribution of the petition. TRL doesn't get punished at all. And so basically their argument here is you need to treat him like you treated us, or you need to treat us like you treated him.
Okay. And what did the court say?
Well, the court says that in order to state an equal protection claim, you have to prove that you are similarly situated in all relevant aspects. And here, you are not similarly situated in all relevant aspects because TRL didn't create the petition, and he also didn't comment on the petition. Yes, though, TRL, according to like change.org's internal documents, he signed the petition. But he said that he signed the petition because he was going to post on it as a coach, pretending to be one of the coaches, basically saying like, hey, you are all going to have to run laps. You shouldn't be doing this. So, but he did sign the petition, but that's not public, right? Like, these comments were public. And so the court looks at this and says, like, TRL, like, even if I accept your version of events, isn't similarly situated because he didn't, you know, he wasn't publicly involved in this petition as you guys were.
Yeah.
And then the other thing you have to prove is that, like, race played an impermissible part in the motivation for the decision. And here, like, there's no evidence that race had anything to do with what they were doing. And like,
or with how the school disciplined them. Yeah.
Right. Exactly. Yeah. Like, it had nothing to do, like, there was no consideration of race in the punishment. You know, race obviously was part of the misconduct, right? Like, they were saying these racist things, but it was not considered in how, like, the student's race wasn't part of the punishment. But the students make an argument about that. And they say that, like, in 2016, the school adopted a policy to essentially address racial disparities in its discipline data.
Okay.
And this came after, like, a lot of schools did this after the Obama administration released their Dear Colleague letter on racially disproportionate discipline. And so the plaintiffs are essentially arguing that, like, the reason you didn't suspend TRL is because you want to balance your racial discipline demographics. So you're basically less likely to punish a minority student rather than a white student. And you know, the court rejects that because they say, like, there's no evidence at all that that was what was motivating these people. And it's also a really problematic argument, right? Like, in the same way that a lot of the arguments from Coalition versus TJ versus Fairfax County were problematic, where, like, they basically were saying anytime you consider race, that automatically makes the decision suspect. Here, like, if the court had accepted that argument, it would have been like, anytime we even consider our racial demographic data, anytime we suspend a white student now is going to become questionable instantly. And like, so, there's some really like slippery slope issues with accepting that argument. So the court dismisses that and just says like, look, there's no evidence here. And that's all the claims that are left. Court dismisses or affirms the dismissal of all of those claims. And of course, that's not the last step.
No, there's an appeal.
There's an appeal, but they ask the Eighth Circuit to hear the case en banc, and the Eighth Circuit just says, no, thanks, we're good. And that was in May of
24.
I think that was in May of 2024.
Yeah.
So, I don't know if they can appeal this to the Supreme Court or not, but like, I think as of right now, this case is concluded.
It's messed up given how much media attention this thing got for a few days and how little it got as it played out or when it ended.
Right.
It's just, I don't know. It's, that's a topic for another podcast.
It just goes to show that like the sensationalization of
exactly.
the media
that's what I'm
cycle,
saying.
right? Like
facts be damned, right? Like, let's put this out there and get everybody to click and turn it on and whatever. And to me, the interesting thing about this case is not the headline, right? It's all the interesting facts and how, the facts of the case, how it all played out in the courts, what had merit and what didn't.
Right. And how the school grappled with it after the fact. Like, I think there's so many good lessons to be learned about crisis management from how this school responded. Yeah.
So on that note, like, make sure your policies are clear. Make sure you follow those policies to a T, whether they're your policies or district or state policies with respect to due process.
Mm-hmm.
Keep those receipts.
As always.
It's it is really interesting to think about how a lot of the advice that we give after a lot of these different cases that we cover is very similar. Know your policies, make sure they're clear, make sure they're clearly communicated, keep your receipts.
And your favorite, relationships.
Relationships, people.
Right?
Relationships.
And that seems to be so much of what they did after all of this came down is they really focused on relationships and the communications with the community, right?
Right. Managing their teachers. It's there's a lot of stuff that goes into these things.
310 hours worth, apparently.
My guess is at least. And board meetings that end at 3 a.m.
Oh my gosh.
Which is potentially when you're ending listening to this episode now.
Hey, if we've got those
lots
nice,
to say.
Calm tones. Like, I could absolutely see someone falling asleep to this.
Oh, completely. All right, folks. Well, that does it for this episode of Chalk and Gavel. Chris, what is our homework?
Oh, your homework is to stay wide awake to our engaging, riveting conversation, and to find Chalk and Gavel wherever you get your podcasts. Like, rate, review, subscribe. Check out our website, chalkandgavel.com, where you can find links to the teaching guide that we mentioned at the top of the episode, as well as our Patreon. So we'd love you all to engage with that. If you can support us, that would mean the world to us. We love doing this podcast, but $2 a month if you want to join at the friend of the show level, that goes such a long way to allowing us to continue to do this and to make it as good as it can be, and to make sure that it's getting to your ears in the best possible quality.
All right, folks. Well, we hope you enjoyed this one, and we hope you enjoy the next one, which will be in 2 weeks. So join us as we explore another case that's connecting the courtroom to the classroom.